Okay, hello and welcome friends. I am Dr. Nandan Sharma, back again from Shoolini University School of Law. I welcome you all to the knowledge sharing session, the second part, which we started last week with my Canadian friend Sebastian, who spoke on the constitutional and criminal comparative laws of India and Canada. And in this series today, again, we have a very interesting personality. I have with me a very budding lawyer from from Himachal High Court, Advocate Sarthak Mehta. We have with us, and he will be sharing his views on mooting skills. So I know that for each and every law student, budding lawyer, the mooting skills, moot courts, drafting, pleading remains the most interesting part to learn. And they are inclined that how can we imbibe all these qualities to be a good mooter or to make good memorials and all. So this is the basic theme on which our today's knowledge sharing session is based, friends. So I welcome Advocate Sarthak Mehta, and I also have with me Palak Sharma, who will be the moderator for today. Palak is a very own student, a research scholar, master's research scholar from Shoolini University. So I hand over to you, Palak. Please carry on.
Thank you so much, sir. Okay, hello everyone. I am Palak Sharma, research scholar, Shoolini University. So I'm very pleased to announce here it is the second series of knowledge sharing session in which we have Advocate Sarthak Mehta. So Advocate Sarthak Mehta has done his schooling from D.A.V Public School, Shimla, and then went to DES NavalmalFirodia Law College, Pune for his B.A.LL.B honors. Advocate Sarthak is currently practicing in the Hon'ble Himachal High Court, Shimla. Along with his actively ongoing practice, he is also a great lecturer and a moot court competition judge at various colleges and private institutions in Pune. As during his college era, he has won multiple moot court competitions and has also been recognized and awarded numerous awards for the oral as well as the written presentations at various national as well as international moot court competitions. He flourishes to inculcate the mooting information to the upcoming lawyers in a more practical and a cohesive manner. He has also acknowledged and published various articles on various legal issues. I welcome you, sir, to the second series of knowledge sharing session.
Thank you so much. Thank you so much, Palak.
So, sir, let's begin with the interview here.
Yes, but just before that I begin with it, I really hope that all of viewers are doing fine at their homes right now. And to start out with, I'd really like to thank the Shoolini University for having me over here in this particular session. And I would like to congratulate the university for its unremitted success too. I thank Dr. Nandan sir too for having me over here and for such a brief and worthy introduction. Thank you so much, Palak.
Thank you, sir.
Thank you.
So, sir, your first question here will be, I would like to ask you that what attracted you towards moot courts and how was your experience regarding mooting during your law journey?
See, let's be very much honest. When a person enters in a law school, there are a lot of captivating activities that he finds. But out of all those activities, I believe mooting was one such activity. Mooting is rather one such activity, that catches a hold on everyone and everywhere in a particular law college, be it a person in his very inaugural first year of the course, be it in the fifth year of the course. So everybody wants to get into the moot courts or the mooting line. I believe so. That was the one thing that motivated me. Let's do moot, let's try mooting, because that was something that I'd done before too in my schooling, but not mooting exactly, but a lot of speaking part. So mooting, for me, when I started out with it, mooting was a very different idea for me. I thought mooting is just limited to speaking and speaking only. But then as I learned more about mooting is an amalgamation of a lot of activities, I'd say. It is an amalgamation of your research, organizing that research, and then how do you use that organized research, making into a written statements or the written, what would be the memorandums, and pointing out towards the oral presentations. So it's an amalgamation of lot of activities, I'd say. And eventually when I ended up understanding what the concept of mooting was, unfortunately it was very late. I was already a pass out from the college. So that's all that I really want to share with all the upcoming law students, the lawyers too, that mooting is one such integral activity that I'd motivate everyone to do so, to participate in it. So I think that was one light of beam that carried me towards mooting too, that it was Kehan. This is the most imperative activity of the law school, and I have to be a mooter for myself. And luckily enough, I didn't have the guides back then. Luckily enough, and I ended up being a decent mooter, I believe.
That's really
So,
great, sir.
Sarthak, this is what
Yes,
I think also, that most of the students remain in this type of condition, that yes, they keep on thinking that yes, we want to be good mooters, we want to do mooting, or they have a passion to go for moot courts, but actually they are unable to at times in most of the
exactly, sir.
colleges, whether those are NLUs even, because it is not
Exactly,
a
sir.
cup of,
Exactly.
yes. So what is the basic, is it a fear factor, or is it just like they do not have that platform to groom themselves?
I'd ideally say, sir, for me and for everyone else, the fear factors comes into the line. You're very much right over there. And what people lack nowadays in the law schools is too, because I would say, sir, mooting was not a very much familiar concept. I think 10 years back in India, or for that
Exactly.
part, for that reason, for any part of the world. So people do not have the guides to inculcate their values and their morals and their ideas towards mooting. The law students particularly, they did not have very much practical guides. And I'm not pointing out towards the teachers, but teachers have played an immensely great role, that they are actually still doing it, helped us all out during our college days too. So I think uh, the lack of that guidance, which comes via practicality, that is one particular reason, sir, why people are not motivated to go over there. And
Yes.
what people think is that moots are only limited to the oral presentation. But as I told you, sir, it's an amalgamation of a lot of factors. The behavioral science also comes in between in this. Your presentation also comes in between. Your
Exactly.
intelligence, your confidence, and your presence of mind. So it is an amalgamation of a lot of activities. And eventually, what we get is a perfect moot. So,
Okay.
Please go ahead, Palak.
Yes, sir. I'll start with your second question, sir. So now I would like to ask you that according to your experience, what are the key qualities which a mooter should have, and how the memorials should be prepared?
see, but like, your question is a multifaceted question.
Yes, sir.
The first part
Actually,
of
I
it
have
is equality.
yeah, I have three
The
parts in
first part
it.
of it,
Yeah, I have
yes,
actually
yes.
three. The third question I didn't ask you right now. I was just focused on
Uh,
these two. Then you can tell
so
me
coming to the
firstly
first,
the key qualities of a mooter.
yes. So for me, I think the number one key quality that in a mooter should be that he should be ready to get embarrassed. I won't call it embarrassment, but it is rather criticism,
Okay,
because
okay,
that
okay.
is what happens. uh, a lot of people, a lot of students too. I mean, I don't know what is happening these days. A lot of students, they have a very fragile egos. They just won't go to the
Yeah,
moot court and get embarrassed out of themselves. So I think the key quality is to get embarrassed, because see, when you understand the word moot means a debatable topic.
yeah,
So there is no pre concluded conclusion towards it. There is no answer to the topic. It is an equally balanced ideal problem. It might go on to the right too, or it might go on to the left too. So the first thing that you have to keep in
yeah,
mind is that you have to forget the thing that something is right about this or something is wrong about this. So this dilemma, if you carry this dilemma about the right or wrong, you can never be a mooter. I'm so sorry. So the first thing is you be ready to face the criticism, because the see, it's a moot problem because there is no meeting of the minds. There is a
yeah.
dispute that has come in between. That is why it's a moot problem at the first place. And now the judge, be it the judge or be it the opposite counsels, they'll be asking you, nagging you down, asking you certain questions about it. So you need to be
Yes,
very much alert and ready to face everything that comes to you. That is the first quality I would say in a mooter. The second one is, I don't think there is any other such specific quality, because anyone can be a mooter. So it's again, I don't know what, as sir said, it's a kind of a fear factor in the back of a head. I don't know what will happen when we enter the courtroom. I don't know
yeah,
how embarrassed would we be. Our peers would be over there looking at us, listening to us.
yes, yes,
So this is the only thing. If you forget this, you can definitely be a very good mooter. And as I said, mooting is just not limited to the speaking part. In a moot
yeah,
court team, as you'd see, normally there are three people. There are
yeah,
two
yeah,
speakers and one is a researcher. But let me tell you, all three of them, initially they're all researchers. It's just that when they enter the courtroom, they are divided by their duties, because it's not that the speakers won't research at all. I think the maximum part of the research should come from the speakers only, because they are the one who
yes,
are going
yes.
to speak the research over there in the court, right? So the first thing is that all three participants or four participants, they're all researchers basically. And when all the students, they work in a team, they inculcate a lot more knowledge that a person can do all by himself alone, right? So yeah, team management and being a part of the team is, I think, the second quality for that. I think, and there
it
is no
can be.
other as such any practical
Do you
example.
think some
The second part of the
communication
question.
skills also needed there?
Communication skills, Palak, I would say communication skills would develop once you start to communicate.
Okay.
If
Yeah,
you
yeah.
अगर आपने past में कभी communicate नहीं किया, you haven't communicated in the past, so I think it would be difficult for you. But once you start out with it, the communication skills, as I would say, your language, your normal parlance, with the language that you use, it changes into the legal language.
Yes,
You
yes.
use a lot of legal lingo phrases in that in the whole course, and law oriented course, this language, I would say. So it all changes, and you develop the habit of speaking in that very much formal and legal courtroom wala language, and that also
Okay.
helps you eventually when you get out of the law school too, because you're entering
Yeah,
the
yeah.
courtrooms, and what the judges expect from you is the legal lingo, of course.
Exactly.
So yeah.
Initially, it might
So
be
coming to the
difficult, but
second,
from time, it will
in it,
grow.
it grows. It definitely grows. So coming to the second part of the question
Yeah.
about the memorandum. So before I jump onto the memorandum, I think I have a very, it's a kind of a lengthy answer to this. A moot for me is divided if I segregate it into some parts. So the first part would be the oral presentation, right? I'll
Yeah.
come to the memorandum
Yeah,
part
yeah.
of this. So oral presentation starts out with everything. The moment that you open your mouth to the moment that you conclude with whatever you say, with the prayer and your very last words.
Yes.
The permissions that you take in the court, the addresses, the way that you address the opposite party, maybe the witnesses and the judges, it all matters. It all is a part of the oral presentation, I'd say. So a speaker has to be very much consistent, confident, and he should be very much aware of the fact that what is going on in the court while addressing the court and speaking out all his submissions and assurances, right? And
Yeah.
so I'll come back to that in a later part of the session, I believe. Now coming back to the memorandum part, the written presentation.
Yeah.
For me, written presentation is equally important as is the other oral presentation too. Both of them, they carry 50-50% of each weightage. So a memorandum, for me, I am a person who likes a very crisp memorandum, and I think I've learned that from my failures, a lot of failures that I've had in my life. What kind of a ideal memorandum should be there? So to start out with an ideal memorandum, the first page, that is the introductory page.
Yeah.
Things should be very much precise, well spaced over there. Name of the competition, your team code, the name of the parties, their positions, appellant, respondent, whatever they are, and the jurisdiction somewhere
Yeah.
below the name of the parties, right? It should be well bordered. If it's not bordered, then also it's all right, right? So introductory page has to be very much crisp. It has to be of such kind that it should make a first impression in the other person's mind that whatever he's going to read, matlab, he should expect a lot of things from the inside of a memo. Coming to the
Yeah.
second page, that is the index or the table of the authorities. So the table of the authorities is just like a book, right? It gives you the whole idea what all contents are over there in the whole memorandum and on what page and on what segment paragraph are those located. So the index of the table of contents, it should just not be limited to the main pointers. Rather, it should also contain your arguments, sub parts of the arguments, the parts of the
Yeah. Yeah.
arguments, and sub parts of the arguments too. So it has to be a very not a very lengthy one, I'd say, but exhaustive one. A
Yeah.
person later on should not get confused with what he's looking for. The third one comes the list of abbreviations. It has to be abbreviations. I think everyone know what abbreviations are, but it has to be alphabetically settled and
Okay.
formatted. It's just what I feel, right? And then comes the index of authorities, another very important page. And a lot of people, I think a lot of mooters, they kind of ignore this too. It is a very important page because a lot of the judges, you sway away their opinion by this particular page because this is the page that depicts your whole research.
Okay.
It should be well constructed, right? The case laws
Yeah.
should be different in a different format, going by the Supreme Court cases and then the High Court, and you of course cannot mention the Sessions Court cases.
Yeah.
And then comes to the statutes, reports, the lexicons that you've referred to, the databases with the last date that you've referred to, those databases to, the international material, reports, and papers. It should be an amalgamation of everything with different heads, I would say. Then comes the
Wow.
jurisdiction page. Now, jurisdiction is again a
Yeah.
very important page because jurisdiction is depicting your locus standi in the court.
Yeah. Yeah. Yeah.
What happens is in a lot of moot court competitions, I've apparently seen it with a team that I was placed against once. The other team, it did not have the appropriate jurisdiction written over there in the memorandum, and the judges, they did not allow them to move to the arguments part. Their whole case went on onto the jurisdiction page, and why the jurisdiction was right as per them. So that might also happen, right? So your jurisdiction has to be very precise and it has to be written very precisely. And then comes to the other part, a very, very important page that's called the statement of facts, right?
Yeah.
So the statement of facts, the first thing that you need to understand is facts and material facts are two different aspects. Facts would be the total scenario of the whole facts. For example, there might be certain cases, certain moot problems where you might have facts lengthing up to 50 to 60 pages, but those are not, all of them are not material facts. So you have to extract all the material part of the whole facts and jot it down in a single page, I'd say. Pointers are is a good way of depicting it. It is rather appealing, I'd say. If not pointers or the numbers or the paragraphs too. So it just has to be limited to one page. The facts should be neutral. Another important thing. A lot of students, what they do is they tend to, try to sway away the opinion of the court by writing one side's fact, the side that they're representing. Rather, it has to be very much neutral. What has to be pointed out eventually is what happened lastly. It should not be in your favor and should not be in the favor of the other person too, right? And then facts is pretty much limited to this. And then comes to the presentation part, as I told. What is rather appealing is this thing. If you point it down, pointers are a very good way. And then comes to the issues raised in the summary of the arguments. Issues raised is a very plain page that will only carry the issues which are concerned. So it's not a very important page, I'd say. But the summary of arguments is a very important page because you are summarizing your whole pleading in those particular 3 to 4 lines. So it has to be, constructed very witty, in a very witty way, I'd say. And lastly comes to the main part, that is the arguments advanced. Arguments advanced is where your memo starts from, actually, when you're arguing, because the judges are referring to those paragraphs over there, the booklet that you've given them, and listening to you simultaneously. So the first thing, both your oral arguments and your arguments advanced, they have to be in consensus. They have to be with each other. It should not happen that there is something else in your memo and you're speaking something else. However, you might skip on to some important parts and you might not speak about certain parts. It is upon the judges to read them out because of the paucity of time, of course. Right. So the arguments advanced, in a particular, if the first issue is introduced over there, the first issue needs to be introduced, like whether a particular person is guilty for murder or not. It would plainly be an answer, yes, he is guilty, or no, he's not. And after that, another important thing, you have to divide the issue into several headings, and then subheadings, right? Once you do so, you have to also keep in mind that the different paras, they should also be divided and numbered accordingly. There should be symmetrical space between the paras, between the lines, the line spacing. There has to be a symmetry maintained when it comes to the font. And another important thing, the citations should be in a very precise, in a very nice manner. What we use generally, I think we used to use the 9th edition of the Blue Book citations, which later on came down to the 20th one. 9th is the main one. So I think it's a must that all the law students, they must acquaint themselves with the Blue Book citations and its concept. And it must always, because if there's no particular format of the citations that is given, what we normally opt for is the Blue Book citation, maybe any of the editions of them, right? And then comes to the last part, that's called the prayer. Prayer is a very formal clause. You have to write what you really want over there, and you have to speak it out as well. So there's not a lot much about that, but again, your written this thing, the memorandum is just not limited to the memorandum itself. Another important part that a lot of people miss in a written presentation is the compendium. You also need to carry the compendium of the cases that you are mentioning or that you are citing in your memorandum. So the compendium has to be an amalgamation of all the cases. If the case is a lengthy one because it's a moot problem, not an actual court, so you just might get the print of the first page and the last page and the important part of that particular judgment. You have to compile it alphabetically or whatsoever manner you are compiling it, but it needs to be compiled rather. And once it is all compiled, it has to be indexed too. So that's about the written presentation for me.
Wow, sir, it was really informative and it was in so detailed that I think if someone watches this video, it will definitely get something with it.
I really hope so.